Hello and a very good afternoon and evening to all those who are watching us here today. आज हम बात कर रहे हैं directly live and we are talking about the updates and the judgments that the Honorable Supreme Court has given us today. तो ये जितने भी जजमेंट्स हैं ये आज के जजमेंट्स हैं एंड दे आर एक्सट्रीमली इंपॉर्टेंट नॉट जस्ट फ्रॉम द पॉइंट ऑफ व्यू ऑफ द लॉ एग्जामिनेशंस दैट वी आर practically going to face eventually, but they are important because इनमें कहीं ना कहीं कुछ बहुत important और बहुत key points हैं जिनको the Honorable Supreme Court ने highlight किया है. Today in this upcoming series जिसमें हम daily आपको कुछ ना कुछ judgments और legal updates देते रहेंगे, हम 4 major pointers की बात करने वाले हैं. हमारे 4 major judgments हैं राकेश कुमार रघुवंशी versus the state of Madhya Pradesh, Sunkari, Tirumala, Rao and others versus Penki, ArunaKumari. Third case है S. Jayalakshmi versus the Special District Revenue Officers and others. And the last is Sadashiv Dondiram Patil versus the state of Maharashtra. These 4 judgments have talked about and discussed some of the major aspects that we have been discussing till now. The first judgment as we talk about is Rakesh Kumar Raghuvanshi versus the state of MP, where the bench comprised of Justice J.B. Pardiwala and Justice R. Mahadevan. The subject matter that the case was talking about was whether the accused was in conscious possession of the contraband under the Narcotic Drugs and Psychotropic Substances Act 1985. बात क्या की है केस ने आज इस जजमेंट में सुप्रीम कोर्ट ने वो 2 मेजर पॉइंटर्स हैं. पॉइंट नंबर 1, व्हाट इज इट दैट वी कॉल एज द कॉन्शियस पोजेशन. सो कॉन्शियस पोजेशन की डेफिनेशन देते हुए हमें सुप्रीम कोर्ट ने ये बताया है कि एनडीपीएस एक्ट के अंतर्गत हम किस चीज को कॉन्शियस पोजेशन मानेंगे. साथ ही में कॉन्शियस पोजेशन डिटरमिन करने के बाद व्हाट इज इट दैट लाइज वेयर इज इट दैट द प्रोसिक्यूशंस बर्डन ऑफ प्रूफ लाई. पहली चीज, conscious possession involves both physical control over the contraband and mental awareness of its presence and illegal nature. A person must not only possess the substance but also have the knowledge of its nature and intent to possess it. So, whereby coming to the point which eventually leads to the prosecution's burden of proof. What does it say? The prosecution must first establish that the contraband was seized from the conscious possession of the accused. Only upon proving this, the burden shifts to the accused under section 54 of the NDPS Act to provide a satisfactory legal explanation for the possession. So, in order to prove the possession, it is very important that you prove the conscious possession of the contraband substance that we are talking about, which is a subject matter under the NDPS Act. Next is the judgment. In the judgment, the court ruled that the prosecution had successfully established the accused's conscious possession of the contraband under section 54. And the judgment reiterates that the conscious possession under the NDPS Act requires clear proof of physical control and mental awareness, thereby stating that only when these proof of physical control and mental awareness comes as a subject matter can we determine what is to be regarded as conscious possession of the contraband substance and thereby makes the person liable under the NDPS Act. Next case that the Supreme Court gave us today was the Sunkari, Tirumala, Rao and others versus Penki, ArunaKumari. The presiding bench was Justice J.B. Pardiwala and R. Mahadevan again, wherein they said that whether a partner of an unregistered partnership firm can enforce a contractual right against another partner under section 69 of the Indian Partnership Act 1932. The prohibition, let's understand this, the prohibition under section 69 applies even before the partnership firm commences its business, and that is what we have to keep in mind. However, exceptions under 69(3) allow suits for dissolution and rendition of accounts even if the firm is unregistered. And let us not forget that an unregistered firm का क्या status को होता है when we talk about the Indian Partnership Act. We need to reiterate and remember section 4, section 5, etc. of the said act. Then The rationale of the court emphasized that the exception carved out under section 69(3) applies regardless of whether the partnership business has commenced. A suit for dissolution of firm would have been maintainable despite the firm's unregistered status. The Supreme Court reaffirmed that a partner of an unregistered firm cannot file a suit to enforce a contractual right, because that is what the law says, against another partner. Instead, the appropriate remedy in such cases is to seek dissolution of the firm and rendition of accounts. Next, we have the case of S. Jayalakshmi versus the Special District Revenue Officers and others. Presiding bench was Justices P.S. Narasimha and Manoj Mishra. Whether the courts have the jurisdiction under section 34 and 37 of the Arbitration and Conciliation Act 1996 to modify an arbitral award. A very important judgment on the point of view of arbitral awards and the enforcement of the same under the Arbitration Act. Observations of the court were: the court affirmed the principle held in the Project Director National Highways versus M. Hakim and another, that the jurisdiction of the courts under sections 34 and 37 of the Arbitration and Conciliation Act 1996 does not extend to modifying an arbitral award. These were the observations that were made by the Honorable Court. The conclusion thereby being, the Supreme Court affirmed that the High Court's reliance on M. Hakim to hold that the modification of the arbitral award under section 34 and 37 is impermissible, thereby meaning that this is something which is an absolute no-no. It also exercised its powers under Article 142 to enhance compensation in the interest of parity and fairness. The case awaits final determination by a larger bench to provide a conclusive interpretation of the court's jurisdiction under section 34 and 37 of the Arbitration and Conciliation Act 1996. The last judgment in today's bite is quick and simple. The case law of Sadashiv Dondiram Patil versus the state of Maharashtra. Presiding bench, Justice J.B. Pardiwala and Justice R. Mahadevan. The case dealt with extrajudicial confession and discovery of weapon. Do not forget to subscribe to the The Law channel so that you can always have access to such topics. Observation was that extrajudicial confession. The court reiterated that the extrajudicial confessions are weak form of evidence and require careful scrutiny. The court emphasized that such confession must be voluntary, free from coercion and inducement, and trustworthy. While the confession made to the village police patil, which was a fact of the case, was deemed admissible since he was not a police officer, the court found the confession to be vague and ambiguous. Then again, let's also remember the case law of Muhammad Inayatullah, wherein discovery of a weapon was a subject matter. Now, what did the court say on the point of view of discovery of weapon is what is stated here. The court observed that the investigating officer failed to adequately prove the recovery of the weapon. Therefore, the conclusion that was made by the Honorable Supreme Court in this particular judgment was, therefore the Supreme Court quashed the Bombay High Court's order reversing the acquittal as extrajudicial confession to a village police patil cannot be relied upon as credible evidence. Another question for all the law aspirants over here, that the village police patil cannot be relied upon as credible evidence. Therefore, the appeal was allowed and the appellant was acquitted of the charges. That's all for today. We will be streaming such lectures again and again and on a daily basis. We will be coming to you with all the legal updates, the landmark judgments, the points that are extremely important to keep you updated so that you are able to ace all your exams where law is a subject matter. Thank you.